Yeah, I can start talking to him. Say hello.
If you have anything else to say,
Okay, Mike, can you hear us okay?
I don't know how strong
I genuinely don't think they're going to feel psyched out by you. I think they're just going to go.
they're terrified.
You do realise we're unmuted as well, don't
Right, we got anyone got sex?
Good to see you all again. Hello.
Are they on mute?
How are you all?
Can they hear us? I don't know.
I have a feeling this guy is because they're American. Yeah, based on he was kind of all for the shots.
I'll take up the background.
Good to see you.
No, we can't. No, we can't. It's a normal thing to do. You can have mine.
The rights of
All right, are you guys?
Just 1 second. I just need to check. Can you hear us?
Yes, we can hear you.
Yeah, it's okay. That's fine.
Right, okay. Lara, do you want to start?
What are we going to find out? Are we ready?
Oh yeah.
Are you, weren't sure who was going to open.
Which side do you feel like should open? You want us to do it, or you guys want to do it?
We'll do it. All right.
You want us to do it? Start. You want them to start or us to start?
It doesn't matter. You know, you guys decide.
Yeah, I think so.
Civil liberties are protected in both the USA and the UK, particularly through the Entrenchment of Rights and our Human Rights Act. And we are aware that both legislatures have passed legislation to further protect these citizens' rights. Given the different political circumstances of our respective systems, i.e. federalism, as an example, we understand how it could be difficult to determine the answer to who protects rights better. However, we believe, given the evident elements of hypocrisy in terms of state versus federal level rights in the US, and taking into account the elitist tendencies, particularly surrounding pressure groups, the UK does, in reality, protect rights better than the USA. Yeah.
Luke, just read it one more time.
Oh, is that it?
Yeah.
Well, mine's pretty long. All right. I guess I'll go with my opening statement. So before I begin, I like to define what a constitution exactly is. It's a system of beliefs and laws by which a country or state is organized or governed by. And here in the United States, we technically do have a written constitution, although it does act as an unwritten constitution. I'll explain. There's a Supreme Court case called Marbury versus Madison. The Supreme Court case that changed our judicial system by giving them power to review the Constitution. In the case, Thomas Jefferson defeated John Adams in 1800 in the presidential election. Before Jefferson took office on March 4th, 1801, Adams and Congress passed the Judiciary Act of 1801. This created new laws that added judges and gave the presidents more control over the appropriate amount of judges. The purpose of the Supreme Court is to settle disputes between countries and states. An example is like a guy from California trying to sue a guy from Texas. The Supreme Court would act as a regular court between the two states. Marbury versus Madison made our written constitution to an unwritten constitution by allowing other judges to decide whether something is constitutional or not. The Supreme Court did not always have this power because our founders did not intend for this to happen. Originally, they were supposed to be settling disputes between different countries or different states or different cases involving the United States and another country. If we did use our written constitution the way intended, we wouldn't have a Supreme Court ruling on and off on issues. A recent example is with the Supreme Court ruling that police officers aren't allowed to perform a community caretaker function due to the Fourth Amendment issue. However, our laws are supposed to act unless the Constitution states otherwise. The states have permission to make their own laws according to the 10th Amendment that allows states to make laws along as they don't violate the Constitution. The problem with an unwritten Constitution is that laws along with individual rights can be changed anytime due to the fact that nowhere it's stated or written on a piece of paper. An unwritten Constitution relies on a goodwill for whoever is in power in this country. Where a written constitution is enacted, the Constitution is the Supreme Court versus a country where there are unwritten constitutions in Parliament in the Supreme Court. And yeah, that's basically it.
So he's basically arguing as belongs on good work. Right, okay.
We mean it. We mean it.
Yeah. No,
One second, please. Thank you.
1 second. Do you want us to continue and kind of throw some more stuff at you, or do you want to come back at us?
Okay, you go and we'll come back after that.
Okay, because when I spoke to Mike, the main focus, we can talk to you about the two constitutions, and actually that's valid for us to do, but we are having a specific focus on rights, but we can definitely talk about constitution more widely, but we wanted to focus particularly on rights. But so I think your main argument, it was about the kind of Supreme Court and the protection of rights, wasn't it? Yeah.
Oh, from what I was told, the topic was supposed to be a written constitution versus an unwritten constitution.
That's a different
Yeah, so when I contacted Mike, we were saying that rights are better protected in the USA than they are in the UK, but we can link it into constitution.
Ah, I see. Okay.
Miss, because we're going to have that debate on the.
Let me talk to Mike very quick. I'll be right back.
I know, I need to.
We can see you.
It's like this. We're not muted.
We're not muted.
He's currently talking with Mr. Cunningham. He's back.
Yeah, you guys go on with your speeches or your camera boards, and we'll continue to give our points. We'll just have to like find a way to like blend our topics in between.
Who's doing the first one?
I mean, actually, about the Supreme Court, especially considering he was one issue anyway, and we had points for that.
Right, who's going to pick it up next?
Oh, sorry. No, it's just information.
Right, Hamlet, why don't you pick up something, or Rona? I know, it's fine.
Yeah, so it's already done that.
Yeah.
Okay, which bit am I reading?
You did this last time, you were perfect last time.
Can I just? Yes, you can just read. Okay. Can they hear us?
I think so. Yes? Can you hear us?
Yeah, we can hear you.
Yeah, it's great.
Okay. It is impossible to consider the protection of rights in the US without considering the Supreme Court and its power of judicial review, as given in the Marbury v. Madison case, and its evident significance in the passing of many key cases of human rights in the US, including Snyder v. Phelps in 2011 and Obergefell v. Hodges in 2015 and Roe v. Wade. However, while Roe v. Wade in theory was a hugely significant development in 1973 and a landmark case in the women's movement, and is still important in later cases such as Planned Parenthood v. Casey, the arguable hypocrisy comes in acts such as the Texas Heartbeat Act brought in March 2021. It became the strictest anti-abortion laws in the country, strongly challenging Roe v. Wade, which, given the importance and power of the Supreme Court, should be enough to establish this as a key right that should be protected. Furthermore, a heavily politicized judiciary in the US greatly impacts an outcome, as Texas Heartbeat Act was voted 5-4 in the Supreme Court not to be overruled on the day it was launched, with 3 of the 5 justices being appointed by Trump, a Republican, who typically supports anti-abortion causes. Thus, challenging of rights endangers people's doctors greatly, as the risk and rights, as the risk of being sued is now more likely, and people are forced to consider either traveling to abort safely or even trying dangerous home abortion methods. This is an evident example of how the US does not only protect the rights they put in place, it shows that rights aren't as well protected. Yeah.
Thank you. Eventually.
Right. So I can understand your argument. I want to like misrepresent it. You're saying that the Supreme Court is important, and because some decisions from some states are not allowing abortion or not is an example of why a written constitution doesn't guarantee all rights, correct?
Yes.
Okay, so I would have to say to that, that's like, it's based on interpretation, because what you see as a right is not what other people see as a right. You viewing a right to have an abortion is not the same as someone else having a right to have a life. I'm not saying this is my opinion, it's just based on interpretation. And because we go by our constitution, we have to follow laws, and like anything our Constitution says so. So the Supreme Court is kind of mixed on the decision right now. That's why it's up to a state issue right now. From all the places that I know of, that all states have legalized abortion, although some have regulation due to like they have like if incest or rape stuff, cases like that. So the argument that we don't have like people don't have the right to get an abortion in the first place is not exactly right. Also, people find that if once a person is pregnant, that the individual who is like inside the woman's womb is their own individual person with their own rights. Until the Supreme Court reviews the Constitution and states that, hey, this person has rights, or hey, we're not recognizing this as a person, then we'll determine whether someone has their rights or not.
Yeah, Bethan, go on.
With the Texas Heartbeat Bill, you said that people could have like an abortion in cases of like rape or incest and stuff like that. That's not true. The Texas Heartbeat Bill didn't allow for abortions in the case of exceptional circumstances. So it was not, you couldn't have an abortion, I don't think, in the case of rape.
It only allowed them in case of medical emergency.
It's a medical emergency. So if the baby of rape or of incest was healthy and people were healthy, abortion still wasn't allowed after the 6-week deadline.
Can you come closer to the mic? We kind of.
Okay, we need to.
Bethan, link it.
Okay, is this close enough? I don't know when like too close is closer. Is this all right?
Yeah.
With the Texas Heartbeat Bill, you said that you could still get an abortion in Texas in case of like rape or incest, but the only exceptional circumstances to the 6-week rule were in cases of a medical emergency. So if the baby stemming from rape or from incest was not posing a risk to the mother's health after the 6-week mark, then you still weren't allowed an abortion, which shows that even though, like as Verona said, like with Roe v. Wade, what was that? How you said that like, you know, it's up to states and that abortion is still technically allowed to a certain point in medical emergencies. It's not. You know, the Supreme Court ruling on Roe v. Wade was supposed to make abortion accessible for women, but if it can be as easily overruled as that to the case where a baby stemming from incest can still be born, then it did not. It didn't protect women's rights. It didn't protect abortion rights successfully. So I'm going to go back.
Well, wait, quick question before you go back. What in your definition would you consider a woman's right to be like protected?
Sit down. You repeat the question. Someone give Bethan a chair.
Do you want to take the chair back?
No, I'll come round. Sorry, wait, we didn't hear part of the question. Can you repeat the question?
What was the question?
What do we define as women's rights?
I would define a woman's right as having right to determine her own bodily autonomy and not having her human rights undermined by a fetus who is not fully developed and would not even be noticeable in a biological sense at the 6-week mark.
Can you ask him what his view is?
We're not just debating abortion, though. We're debating rights and the protection of rights. And his question is a valid right. It's like, whose right? Okay, go on.
In the case of women's rights, if your side is an argument that abortion, like if we're counting abortion as not women's rights, which is another debate, but if we're just talking about women's rights in America, America is the only developed country in the world to not pay women maternity leave, and I think that sort of large sort of aspect of misogyny and not respecting women's rights in America probably does stem from the fact that the Equal Rights Amendment, which was to officially prevent discrimination on terms of sex, was never officially passed in the Constitution. So, you know, you can say that the Constitution is great and that it protects everyone, and that's fantastic, but the fact is that you do need amendments to continue with the times, and you need the Constitution to be flexible, and you need a country to change as society changes. And the fact that your abortion is entrenching outdated liberties and outdated rights means that women are still at a huge disadvantage in your country, which you can either see in abortion rights, or if you don't want to believe that abortions are women's rights, you can see it in how America doesn't pay women maternity leave, and it's the only developed country to not do so.
We need to talk about the advantages of the interpretation. We need to talk about the advantages of the interpretation. To do like
Okay, do you want to present us with another part of your argument, or do you want us to keep going?
I was gonna say something, but I forgot. So, okay, I'll make this quick statement, and then I think we should move on because we have other speeches we have to go through. Well, because you're saying that the Constitution can't be changed, that's incorrect. We can always add amendments to the Constitution. It just takes a process, and it's because of these processes we are allowed to add rights and have these rights protected. So again, it's based on interpretation, whether it's someone's right to live or someone's right to have an abortion, or it's however you want to look at it. So I guess what you perceive as having a right or having a freedom is different from what others perceive as having a right, having a freedom. And because of that, we can't necessarily make a law based on what others perceive as freedom and others perceive as not having freedom. That's all I can say. And if you guys want to have a counter argument to that, go ahead. And right after, we're going to move on to our next speech.
Can I say one super quick point to that abortion thing and then move on from that? But you say that it's a case of interpretation, which I think is true, and I think it's good that you interpret the Constitution because obviously it was written a very long time ago. But I think the issue is when you start interpreting it in cases where it really shouldn't have a say. So, for example, abortion was not a thing when the Constitution was written. It was not a thing. It was not a healthcare procedure. There weren't stances such as being pro-life and pro-choice. The founding fathers did not know what abortion was, and yet people in American society use the Constitution to justify why abortion should be completely illegal. So I think you sort of reach a point where you need to maybe just accept that your Constitution is potentially quite outdated, because saying that you can interpret it, but even on cases where the people who wrote the Constitution didn't even realize that these things were going to be an issue in the future. So I think, yeah, it's not really a case of interpretation when the thing that you're interpreting it on wasn't even vaguely mentioned in it. So moving on.
Does nobody want to say anything about the amendments process? Go on.
The amendments process in the US takes 3/4 of the states and 2/3 of the set of Congress to approve, which is a very unlikely event. An example of this is the Equal Rights Act that has never been passed in America.
And how many amendments have they got?
There's only been 17 extra amendments over 200 years, which means that they're really hard to do.
Beyond them.
Yeah.
Oh, swapped.
All right.
Okay, so your argument proves our point. If the Supreme Court can change the Constitution, we do not have one, correct?
We have a constitution, it's just uncodified. We have a constitution. I hope you do know that.
If the Supreme Court can change our Constitution, do we have one or not?
Do they have one?
Yeah, you do have a constitution.
The Supreme Court doesn't change it, the state Congress.
Yeah.
But
Are you asking us if you have a constitution?
if we have a written Constitution, but so if the Supreme Court can just change it, is that still a Constitution?
Yeah.
But the Supreme Court can't just change it. So
We've just argued that the Supreme Court can't just change it.
The Constitution is so easily changed that we don't have we can't call it.
No, they're saying, do they have a constitution that is fixed if the Supreme Court decisions can change it? And you've been arguing that Supreme Court cases have changed their constitution, and therefore how robust and stuck is their constitution? Because if your argument is that it doesn't change, and then you say, but it changes with Supreme Court justices, how
Okay.
is that your argument? Sorry.
Yes, it is.
Yeah. But their Supreme Court also changes in its membership.
But isn't that whole argument about their rights for inalienable?
What?
Yeah.
I'm slightly confused about your point. If you're saying that the Supreme Court cases can alter your constitution and things like that, isn't your whole argument based off of the fact that your rights are inalienable and can't be changed by the flexibility of society? So surely by saying that point, you've undermined the basis of your argument of why rights are well protected in the US.
Could you repeat that last sentence? Sorry.
Basically, because you were saying that the Supreme Court cases can like alter your constitution. I think, was that what you said?
Yes.
Yeah. But surely that then undermines the entire like basis of your point, because the whole basis of, I guess, why you can argue that rights are well protected in the US is because they're inalienable and that the Constitution remains regardless of how society changes. So surely by saying that, you've undermined the whole basis of your argument.
I suppose so.
Have you got something you want to share with us?
Marbury versus Madison in 1803 changed the rule of Supreme Court. We have we have a written constitution, but because of that, sorry, let me rephrase that. When Marbury versus Madison in 1803 changed the rule of Supreme Court, we have not a written constitution.
Well, they do. They have a codified constitution. Yeah, in fact,
We have a copy of the Constitution. I'm pretty sure it's written down.
yeah.
I don't mean to be rude.
Yeah, I do. We have these seconds hours, they're not getting theirs, they probably have really good forces. Yeah. Letters. We've still got to do some stuff on constitution for the American side. See, we're very good at meeting with it. Yeah, I do. They've
The
gone.
written Constitution that you do not have, I'm holding it right here. A copy of it, in fact. I would like to understand what you mean by you don't have a written Constitution. You want me to bring it closer to you?
No.
We the people of the United States, sorry.
Don't see me in face. Hi, you all right?
Yeah, sorry, we had a announcements going on and we didn't want you guys to hear it.
All right, okay. Only because we better warn you that we have to wrap up very shortly, and we fully appreciate that. Obviously, there was a miscommunication about the topic that we were going to do today, and so we appreciate that as well.
can I like summarize what we're trying to say, because I think there's a bit of confusion.
Yeah.
We're
Bro.
trying to say you guys can't use our laws like Roe v. Wade as an example as a written constitution, because what we have here in the United States is not acting as a constitution right now. The fact that we have a Supreme Court just proves that our constitution is not acting as it's supposed to by our founders. Our founders never intended to have a Supreme Court. They never wanted judges to decide whether this issue is unconstitutional or not. So you guys using examples here in the United States, whether some people are having freedoms or some people are not having freedoms, it can't be used. And if it were used differently, if there's not really an example of a country that has had a written constitution and actually practices laws by a written constitution, usually something changes within that country that makes the government have more power over what their original document had. And that's what we're saying.
This is a fun fact.
Yeah, but I think if you're arguing constitution, what would you argue in return to that it's not as it intended? Did the founding fathers intend it to be vague, or did they intend it to be strict?
So what we're trying to argue is that a written constitution is actually better than an unwritten one. But what I was trying to say is that you can't really use an example or pull up one, because how can I put this? A written constitution hasn't really been tried or practiced in a country, especially or not long enough for it to.
But it's been practiced in many countries.
How many countries don't have a codified constitution?
You can argue that all countries have a constitution.
No, but a codified written one in a single document. There's only 4 countries in the world that don't have it.
The codified one. Arguing that, like, in theory they have it, but like in practice they don't actually practice what their constitution says.
Just 1 second, one person at a time. Who wants to comment on it? Go on, Tina. No, nobody wants to comment on the fact that they don't believe that a written constitution acts as a written constitution, as a codified document.
That's such a
A written constitution doesn't really act as a written constitution when you're basing off of interpretation.
What's the point of the argument there? It's just
But what you're saying is everything can be interpreted.
Yeah.
Is that your argument? And therefore it's written down, therefore it doesn't matter whether it's written down because it can be interpreted.
Sure, let me give you an example.
Yeah, wait.
So there would be a Supreme Court case saying that whether a police officer or a police officer can do something or not, if they have the right to do it. And they will make a decision later saying, okay, it's constitutional. And then a few years later, it's unconstitutional. If it was a written constitution acts as a written constitution, it would be one or the other. It wouldn't be switching.
The reason why it's a written constitution is because the Supreme Court looks at the written constitution and says, hey, this thing that the founding fathers wrote down said that they weren't allowed to do this, and that's why the act gets repealed. That's why you have acts that violate your constitution. It can violate something, but in order to violate it, your constitution has to exist and it has to be codified. Yeah, and be important.
But if it's codified in the correct way, I'm not saying it can't be codified. It could be practiced in saying, hey, this is constitutional or not. But the fact that it's really based on what other people want or what other people believe, it can't really be practiced truly or honestly. Like there'll be parties that would vote against a case based on their influence and their own beliefs, ignoring the Constitution, which is like is their job. Their job is to uphold the Constitution, but just because it's their job doesn't mean they actually do it.
And wouldn't you argue that in the Constitution that you say is invalid because of the way it's interpreted, in actual fact, there are, what do we learn about those against the possession of guns in the Second Amendment? Is there a large movement against this?
60% of Americans would vote to take away the Second reform the Second Amendment. But so how?
But it's held in such value and such self-esteem and used as a justification for protecting those rights that, as a codified document, it does hold value.
It's okay. It's supposed to hold value. The fact that that the people are the way they are today, the fact that our Supreme Court judges can be influenced, shows that it's not codified, or it's not. It doesn't really mean anything.
The Constitution doesn't mean anything.
Then would it not matter if it was uncodified? Then why don't they abolish it?
Why not completely repeal your entire Constitution?
Get rid of it. If it doesn't mean anything, get rid of it.
Why has it not been abolished since the 17th century?
Last thing I would say to that is we can't really repeal it because some people want to keep the Constitution and some others. It's if all of us were in favor and having the same beliefs, and yes, we would all say, hey, let's abolish our Constitution, let's reform it. Instead, people want to keep it, other people don't want to keep it. So because we have a mixed country and it's divided and people have their own beliefs, we can't really make it all have one decision at the same time. If we did, things would be different, and we would have like an unwritten Constitution or reform.
Entirely then, what is the point in your federal system?
Surely the Constitution was to create the United States of America.
That unite you together. What is the point of having a federal system if you do not believe that you can be united together?
The difference was that back then there wasn't really any separation between the beliefs of the people who were in power. They were all in agreement, and that's why we had a written Constitution. Is because the people
Really, there wasn't a differentiation between the founding fathers and those who believed in a federal and anti-federal system. The founding fathers themselves were divided over federalism, weren't they?
As well as the states themselves.
They were, but they had a conference, they sat down, they discussed it, and they actually had to agree whether the laws of the Constitution were good or not.
I am really sorry, as you can probably see that.
I know.
Yeah, we've got to go. So what I'm going to do is I'm going to. If you want to say, I've got to go to a meeting. That's the trouble. I've got to take my laptop. Okay. Yeah, what we'll do is we'll plan another session where we're both arguing the same area, right?
Yeah.
It's a bit clearer. Yeah. Okay. Thank you for that. And that's not your fault. That's the and I'm not blaming Mike. That's just miscommunication between the two of us.
Right. We had fun.
Yeah. I'm sure you're not loving us, but
Actually, part of the problem, mine, I'll admit, the gentleman that was going to come to debate with you guys. We thought was going to be in a little bit, so he wasn't going to come to earlier. So we had a unique argument, and our argument was going to be about rights. And we have ascertained the fact that in 1803, in the Marbury versus Madison case, the Supreme Court ruled in a 4-0 decision that that a judicial act of 1789 was unconstitutional. Now, according to Article 3 of the Constitution, they had no ability to do that. And to make it even more egregious, the gentleman who is the Chief Justice of the Supreme Court was the one who was involved in the case in the first place. So he should have accused himself. So he had a basic grab for power. And ever since then, you could make cases that our written Constitution is not, we were never entitled to have 3 equal branches. The original Constitution, Congress had about 2/3 of the Constitution. The president had about 1/3, and then you had just a little bit of side thing for the judicial system. So Congress was going to be over the judicial system, and the Supreme Court kind of took this power upon themselves. And then since then, our rights are being kind of created by the Supreme Court. So much so that, like in school right now, there was a New Jersey case of 1985, New Jersey versus TLO. And that's how you can actually get searched here at school. Kids at school have very few rights. I don't necessarily think that this should be against the Fourth Amendment. So the argument would have been is that we are not upholding our rights by allowing the Constitution to be interpreted by Supreme Court justices instead of going by the original intent, which from 1789 to 1803 was a very weak Supreme Court. In fact, I believe it was Clinton. No, it's John Jay. John Jay tried twice, first unsuccessful, then he ran for governor of New York, got out of the Supreme Court and said he'd rather be governor because it was much more powerful. So today, we were going to end with the argument that, you know, George W. Bush won the election by 1 vote in a 5-4 decision in Bush v. Gore. So the Supreme Court has become a extremely powerful situation, so much so that a lot of people don't realize it. And that was what our arguments were about rights.
All right, okay, because we thought you were going for that your rights are better protected than ours.
Yeah. And actually, I think in theory they would be, but in actuality and how we conclude is this: whether you have a more specific constitution or a smaller written constitution, if you are in up to interpretation, you really don't have any rights. I think that we would, in theory, be better off than not having a written constitution. But our written constitution has left us a long time ago, and now today, I'm not so sure if we could make a claim the United States would have any more rights, because our rights could vanish in a second, you know, and that's what we're trying to argue.
Right. You see, that's very interesting for you. So you could put in the argument that certainly they believe that since Marbury versus Madison and cases of judicial review have undermined the power of the Constitution to protect any rights, and they're much more fluid. That's their argument.
Yeah. We didn't effectively do it because our people, I guess we forgot about, we went on a daylight savings time, so we are an hour ahead.
Yeah,
so
sorry.
The person was going to argue that. I got to apologize to him because he's been practicing, but that's what his argument was going to be.
Right, do you know what we'll do? We will look at kind of rescheduling, see where we can fit it in. Yeah, we'll keep going. We'll be back. Yeah, we're off for 2 weeks, so we'll look at a date after that.
Okay, that'd be great. That's no problem. I really appreciate it because I think the argument is actually pretty sound if it's explained properly, because you look at, we have a constitution, and we're not arguing we don't have a constitution, but effectively it's kind of been usurped. And when you allow 9 people to kind of control people's rights, then it's very easy to declare, you know, different things, we have rights or not. And when you guys mentioned about Roe v. Wade in 1973, that's a perfect example, because they created the privacy that did not appear in the Constitution, and it was again on Justice Berger's comments on the thing. So you can go back and see all kinds of different court cases where they have modified people's rights without them really even knowing it.
Right, I'm going to get in touch with you, Mike, because unfortunately I've got to go to a meeting as well.
Okay, sorry. Thank you.
All right, no worries. Thank you.
Bye. Thank you.
The students, we really appreciate it. Thank you.
Thank you.
Bye.
Bye.